Hi, this is Amy from Good Food Unearthed, and you are tuning into part 4 of my series on human rights as a basic overview of the human rights and violations from the COVID-19 measures. This is for information purposes. Again, it's a starting point. So please do your own research and investigations and know what your rights are and how to defend them. So we're going to look today at the rights from medical law, both from Canada and internationally. So let's look at Canadian medical law. Well, informed consent is the ethical cornerstone of the practice of medicine. Every medical professional, including nurses, is taught the theory and application of medical ethics. As such, nurses understand that informed consent is the foundational medical ethic on which ethical medical practice rests. Nurses also understand that obtaining informed consent from the patient prior to any medical procedure, including vaccination, is an essential requirement both legally and ethically. Every human being, prior to submitting to a medical treatment that carries known risks, has the right to know the risks and side effects that can result from such a medical treatment, has the right to consider the risks and benefits prior to making a voluntary informed decision, and has the right to accept or reject the treatment. Informed consent to medical risk taking is accepted as a basic human right. Canadian medical law stipulates that patients must be informed of all material risks, no matter how small or remote, prior to consenting to any medical treatment. The consent must also be voluntary and not obtained through coercion, manipulation, or fraudulent information. When voluntary informed consent is not properly obtained prior to any medical procedure, it constitutes a battery as articulated by Canadian medical law. The Canadian Medical Protective Association, CMPA, provides clear guidelines that inform consent for doctors and other healthcare providers. Their detailed document on the requirements for valid consent states that, quote, for consent to serve as a defense to allegations of either negligence or assault and battery, it must meet certain requirements. The consent must have been voluntary. The patient must have had the capacity to consent, and the patient must have been properly informed. The document goes on to emphasize that as the law on consent to medical treatment has evolved, it has become a basic accepted principle that every human being of adult years and of sound mind has the right to determine what shall be done with his or her own body. Clearly, physicians may do nothing to or for a patient without valid consent. This principle is applicable not only to surgical operations, but also to all forms of medical treatment and to diagnostic procedures that involve intentional interference with the person. I'm going to state that again. This principle is applicable not only to surgical operations, but also to all forms of medical treatment and to diagnostic procedures that involve intentional interference with the person. Furthermore, the context of voluntary consent, the CMPA guidelines caution that patients must always be free to consent to or refuse treatment and be free of any suggestion of duress or coercion. Consent obtained under any suggestion of compulsion, either by the actions or words of the physician or others, may be no consent at all and therefore may be successfully repudiated. Canadian Medical Association's Code of Ethics states that In section A, we're going to go over the virtues exemplified by the ethical physician, and then we're going to look specifically at the statement on the commitment to respect for persons. So it states here that trust is the cornerstone of the patient physician relationship and of medical professionalism. Trust is therefore central to providing the highest standard of care and to the ethical practice of medicine. Compassion. A compassionate physician recognizes suffering and vulnerability, seeks to understand the unique circumstances of each patient and to alleviate the patient's suffering, and accompanies the suffering and the vulnerable patient. Honesty. An honest physician is forthright, respects the truth, and does their best to seek, preserve, and communicate that truth sensitively and respectfully. Humility. A humble physician acknowledges and is cautious not to overstep the limits of their knowledge and skills or the limits of medicine, seeks advice and support from colleagues in challenging circumstances, does not try to censor them, and recognizes the patient's knowledge of their own circumstances. Again, you are your own person, you are autonomous. Integrity. A physician who acts with integrity demonstrates consistency in their intentions and actions and acts in a truthful manner in accordance with professional expectations, even in the face of adversity. Prudence. A prudent physician uses clinical and moral reasoning and judgment, considers all relevant knowledge and circumstances, and makes decisions carefully in good conscience and with due regard for principles of exemplary medical care. Now, that's all well and good, but what's most important in that patient physician relationship is the commitment to respect for persons. Always treat the patient with dignity and respect the equal and intrinsic worth of all persons. Always respect the autonomy of the patient. Never exploit the patient for personal advantage and never participate in or support practices that violate basic human rights. Any physician who is in violation of that ethic is in violation of the Canadian Medical Association's Code of Ethics. And the Nuremberg Code on Informed Consent, again, this treaty that Canada is signatory to, this is actually a constitutional guarantee here in Canada and not just a guideline. Number one, the voluntary consent of the human subject is absolutely essential. This means that the person involved, and we're talking about human experimentation, medical, scientific, and with the social distancing, with the lockdowns, with the mask mandates, with the vaccine, that's all experimental. It requires your voluntary consent. This means that you, the person involved, should have legal capacity to give consent. You should be so situated as to be able to exercise free power of choice without the intervention of any element of force, fraud, deceit, duress, overreaching, or other ulterior form of constraint or coercion, and you should have sufficient knowledge and comprehension of the elements of the subject matter involved as to enable you to make an understanding and enlightened decision. There was a case in the UK, Montgomery v. Lanarkshire Health Board. The Supreme Court ruled that the decision of the House of Lords should no longer be followed as it was based upon a view of a doctor-patient relationship that ceased to reflect reality. And this was a patronizing type of relationship where the doctor held the ultimate choice and the patient was the subject of the doctor. It was a paternal type of approach to healthcare. In this court ruling, it stated that the patient should not be viewed as uninformed and incapable for understanding medical matters, but as adults capable of understanding that medical treatment is uncertain of success and may involve risks of accepting responsibility for risks affecting their lives and living with the consequences. It is ultimately your choice, you, the individual. It's not up to your doctor, it's not up to a medical expert to decide for you. That is not their job. The Universal Declaration of Bioethics and Human Research also states in Article 6 on consent, any preventive, diagnostic, and therapeutic medical intervention is only to be carried out with the prior, free, and informed consent of the person concerned based on adequate information. The consent should, where appropriate, be expressed and may be withdrawn by the person concerned at any time and for any reason without disadvantage or prejudice. Now, the best way to have expressed consent is to have it written down and documented and signed by the person, going through a checklist of everything that was, all the information that was given to the patient. And that is the best documentation of consent. If you have written consent, um, that can be held up in a court of law. Now, this goes for, again, any preventive, any diagnostic, and any therapeutic medical intervention. We're talking about social distancing, mask wearing, hand washing, the PCR testing, the antibody testing, the contact tracing. All of these things need the prior, free, and informed consent of the person concerned. Let's look at a couple of other international declarations that involve medical care. And this is from the World Medical Organization. We've got the Helsinki Declaration on Medical Research Involving Human Subjects. This is closely related to the Nuremberg Code that came from the Nuremberg trials. This is some of the statements and their basic principles from their original 1964, I believe, their original document. Number 1 states that clinical research must conform to the moral and scientific principles that justify medical research and should be based on laboratory and animal experiments or other scientifically established facts. With these vaccinations that are coming out, they've skipped over animal trials and they're going into human trials. And they've tested only, before being released to the mass population, they've tested only a specific subgroup of the population and not the populations that are being targeted for these vaccinations. Part 3 states that clinical research cannot legitimately be carried out unless the importance of the objective is in proportion to the inherent risk to the subject. Now, when you look at regular vaccinations, the risks involved with that is you have a 2.5% death rate. That's expected. That's stated from the New England Journal of Medicine, and you can find that in my webinar on investigating the science, and that's on my website as well. And so you have a death rate that is about 2.5%, and you have an adverse event rate of around 20%. And this is normal, this is to be expected. But with the statistics from COVID-19, even though we know that it's been intentionally jacked up in numbers, the infection fatality rate of COVID-19, as stated by the World Health Organization, is around that of the seasonal flu. And the survival rate is around 99%. Now, for people who have two or more comorbidities, they're in a serious state of ill health, and they're also elderly. You have around, at least in the US, the statistics show a 96% chance of survival. So we're looking at this risk benefit ratio, and is the importance of the objective proportionate to the inherent risk to the subject? The evidence would say no. Now, 4 states that every clinical research project should be preceded by careful assessment of the inherent risks in comparison to foreseeable benefits to the subject or to others. And 5 states that special caution should be exercised by the doctor in performing clinical research in which the personality of the subject is liable to be altered by drugs or experimental procedure. And with neurological effects being a strong side effect of vaccinations in general, this is something that needs to be greatly taken into consideration. Part 2 states with clinical research combined with professional care that, if at all possible, consistent with patient psychology, the doctor should obtain the patient's freely given consent after the patient has been given a full explanation. And in part 2 of this, it states that the doctor can combine clinical research with professional care, the objective being the acquisition of new medical knowledge only to the extent that clinical research is justified by its therapeutic value for the patient. And as it stands now, all the evidence shows that with these measures being taken with COVID-19 and with the vaccinations, there is no justification. Part 3 in the non-therapeutic clinical research states that in the purely scientific application of clinical research carried out on a human being, it is the duty of the doctor to remain the protector of the life and health of that person on whom the clinical research is being carried out. The nature, the purpose, and the risk of clinical research must be explained to the subject by the doctor. Clinical research on a human being cannot be undertaken without his free consent after he has been informed. If he is legally incompetent, the consent of the legal guardian should be procured. The subject of clinical research should be in such a mental, physical, and legal status to be able to exercise fully his power of choice. Consent should, as a rule, be obtained in writing. However, the responsibility for clinical research always remains with the research worker. It never falls on the subject even after consent is obtained. The investigator must respect the right of each individual to safeguard his personal integrity, especially if the subject is in a dependent relationship to the investigator. At any time during the course of clinical research, the subject or his guardian should be free to withdraw permission for research to be continued. The investigator or the investigating team should discontinue the research if, in his or their judgment, it may, if continued, be harmful to the individual. Now, the Declaration of Geneva is considered the modern Hippocratic Oath, and that's something to look into. But let's just jump to the bottom where it states, I will maintain the utmost respect for human life, and I will not use my medical knowledge to violate human rights and civil liberties, even under threat. I make these promises solemnly, freely, and upon my honor. And let's look at the original Hippocratic Oath, where it states that I will apply for the benefit of the sick all measures that are required, avoiding those twin traps of overtreatment and therapeutic nihilism. I will not be ashamed to say I know not, nor will I fail to call in my colleagues when the skills of another are needed for a patient's recovery. I will respect the privacy of my patients, for their problems are not disclosed to me that the world may know. Most especially, I must tread with care in matters of life and death. It is given to me to save a if it is given to me to save a life, all thanks. But it may also be within my power to take a life. This awesome responsibility must be faced with great humbleness and awareness of my own frailty. Above all, I must not play at God. I will remember that I do not treat a fever chart, a cancerous growth, but a sick human being whose illness may affect the person's family and economic stability. I will prevent disease whenever I can, for prevention is preferable to cure. I will remember that I remain a member of society. If I do not violate this oath, may I enjoy life and art respected while I live and remembered with affection thereafter. So we have these ethics to uphold from physicians, and the Declaration of Tokyo, the guidelines for physicians to prevent torture, states that it is the physician's duty to heal, to alleviate suffering, to provide comfort, and to act in the best interest of his or her patients. And remember, that includes ultimately the respect for their autonomy. It is the patient's choice, not the doctor's. So, the World Medical Association was founded in September 1947, shortly after the Nuremberg trials, where the abuses of medicine in concentration camps, including brutal acts of medical experimentation and torture and euthanasia activities. What does this remind you of? We have medical experimentation going on right now with the massive lockdowns, mask mandates, social distancing, and the vaccinations. And we have torture, especially psychological torture. And we've had DNR orders, do not resuscitate orders. Now, this happened as well in Nazi Germany, and they were brought to the world's attention. The abuse of medical knowledge still exists in many parts of the world today, in spite of the Nuremberg trials. This declaration states that while physicians have an obligation to diagnose and treat victims of torture, they are ethically prohibited from conducting any evaluation or providing information or treatment that may facilitate or perpetuate torture. Such actions imply a physician's participation in torture. This is not only unethical, but also facilitates the acceptance of such procedures, ultimately destroying patients' trust in the medical profession. The Declaration of Taipei revolves around research on health databases, big data, and biobanks. Those tests that you're getting for COVID-19, you need to ask yourself what is actually happening with that. Why are you getting a nasal swab that goes all the way back to the end of your nasal passages? What is the purpose of that? So, a health database is a system for collecting, organizing, and storing health information, and a biobank is a collection of biological material and associated data. Biological material refers to a sample obtained from an individual human being, which can provide biological information, including genetic information about that individual. Health databases and biobanks are both collections on individuals and population, and both give rise to the similar concerns about dignity, autonomy, privacy, confidentiality, and discrimination. Research using health databases and biobanks can often significantly accelerate improvements in understanding of health, diseases, and effectiveness, efficiency, safety, quality, and so on. However, there needs to be respect for the dignity, autonomy, privacy, and confidentiality of individuals. And the consent, again, you need informed consent that needs to be voluntary, that needs to be given freely for the collection of your data. Consent is only valid if the concerned individuals have been adequately informed. Individuals have the right at any time and without reprisal to alter their consent, and an independent ethics committee should confirm that each exceptional case is justifiable. In terms of governance, you need the protection of individuals. You need transparency. You need participation and inclusion, which means consulting and engaging with individuals and their communities about your intents and purposes, and accountability. So let's look at this because we're seeing a global harvesting of genetic data, of personal biomedical information. And we do know that Oracle and Palantir and I believe it was Google as well, are going to be monitoring people who get the vaccine because that nanotechnology is going to be transmitting data, your biomarker information, to an operations center. That's how they're going to be tracking your status. So, one of the things that wants to come out of this is something called predictive medicine, where they can predict based on the information they are getting from you from that those technological devices, whether they're inside of you or wearable technology. That biometric data will suggest to them what you need. They will say, we can predict a fever before you even get one, so we'll send you the medication or we'll send you the vaccination, and then you can take that. You must take that, and that'll be recorded and taken down. And who are some of the top predictive medicine companies except Pfizer and AstraZeneca, two of the producers of COVID-19 vaccines? Now, this vision for personalized medicine is born through genetics, and it's sold as this wonderful thing where you'll be able to be treated on an individual basis based on your genetics, your phenotypic information, with the use of nanotechnology. And they talk about a third technology that's going to be now this is from 2010, and we're going to talk about how he says individual genomes will become a standard of medical records in 10 years or so, right? So 2010 to 2020. He says we will have the power to make inferences about an individual's health when combined with phenotypic information. Then we can begin to plan strategies for individual healthcare in ways we have never done before. Nanotechnology approaches to protein measurements, such as measuring 2,500 proteins from a drop of blood, will also be important. The third technology that is going to be transformational is the ability to get detailed analysis from a single cell. We can analyze transcriptomes and RNAomes and proteomes and metabolomes, the collection of transcribed genes or messenger RNA, total RNA, protein, and metabolites respectively in the cell. That information will reveal quanticellular states that will say lots about normal mechanisms and disease mechanisms. The final driver is going to be what I generally call computational and mathematical tools, the ability to deal with data dimensionality that is utterly staggering. If we have patients in 10 years with billions of data points, being able to compare that with individual genotype phenotype correlations will give us deep and fundamental new insights into predictive medicine. He also states that medicine is going to become an information science. The whole healthcare system requires a level of IT that goes beyond mere digitization of medical records, which is what most people are talking about now. In 10 years or so, again, this was written in 2010, so we have 2020, we're already here. We may have billions of data points on each individual. And the real challenge will be to develop information technology that can reduce that to real hypotheses about that individual. Now, I want to bring up eugenics because eugenics was the study of genetics with the aim at discovering how to alter the gene pool of a species for its perceived benefit. Now, of course, this was highly biased, and there was the belief that genes transfer fixed abilities. And the early manipulation was through population control methods with forced sterilizations, inhumane medical experiments on animals and people, including but not limited to lobotomy. The modern face of this is genetics. The approach as the same belief in genes and fixed abilities or traits, and the manipulation techniques are more sophisticated now with genetically modified organisms, nanotechnology, and so on. Genetics, what it does not take into account is epigenetics and your microbiome. So epigenetics means that when you change the way that you eat, the way that you think, the way that you feel, the way that you interact with your reality, you actually change the genes that are expressed. You upregulate some and you downregulate others, which means you activate some and you deactivate others. And this is really cool. And on top of that, your microbiome makes up the majority of your genetic code. And your microbiome is influenced highly by your exposure to an environment, to the foods that you eat, to wherever you go, if you're out in nature, if you're inside, who you're interacting with, because you're always exchanging microorganisms constantly. So you're constantly being tuned in to your environment for any changes that are occurring. So let's look at COVID-19 and how medical martial law is reigning supreme. We have the Provincial Health Protection and Promotion Acts, and these basically are granting permission to medical officials to override patient rights, human rights, property rights, consent, constitutional law. There's no liability for the people who are acting upon this statute, and it's employing the excuse of an emergency, a declared emergency that's based on judgment. In Canada, it's based on the judgment of the lieutenant governor on one person. And again, that emergency has not been demonstrably proven and justified. There has been no transparency, and the infringements on charter rights and freedoms, these infringements have not applied to any of the stipulations in Section 1 of the Charter. But it doesn't seem to matter because people are going along with the medical martial law anyways. So I'll state again here that the Constitution is stated in Canada as the supreme law. And within the Charter itself, the first statement says that it is in recognition of the supremacy of God and the rule of law. So the Constitution is below natural law, and every human being is subject to the law. Nobody is exempt. And then you have below the supremacy of God and the rule of law, the constitutional law. And that should uphold. It is designed to be there to respect and protect, which is the duty of a state that has signed the Declaration of Human Rights. It is a duty to respect and protect your inherent, inalienable human rights and freedoms. So we're going to end here with the crimes against humanity, and that's going to be our final section and what it means to be human. So thank you for taking this. That was part 4 on medical law in Canada and internationally, and informed consent, which is so essential. The informed consent. Now, we cannot expect that another person is going to provide us all the information that we need to make a fully informed choice, which is why we each have to become individually sovereign, masters of ourselves, and take personal accountability, do our research, investigate, and say, I am making my choice. It is my body, my physical and psychological well being, and I am ultimately responsible for that. So I will do my research, I will investigate, and it will be my choice, not my doctor's, not the chief medical officer, not an unelected expert or even an elected expert. I have not chosen for this person to be my master, and I, their slave. I am born free, which means I am not subject to the obligation or will of another.